Welcome back. Doctors are angry and worried about the new criminal laws. Section 106 of the new Bhartiya Nyaya Sanhita specifies medical negligence as a criminal offence and allows for fine and jail up to 5 years along with fine. Earlier, under IPC 304A, this was not specified and the term medical practitioners was not included, it was not defined. Also, it was fine or jail. You could get a fine or you could get 2 years of jail. Now it is fine and jail. That means you will go to jail and you're going to be fined as well if medical negligence is proved. Now, all of this, the law now makes jail term mandatory. Remember, Supreme Court earlier largely maintained that a doctor cannot be held accountable for medical negligence when a doctor, using all due care, opted for one method over another, which would also qualify as reasonable course of treatment. Remember, doctors have always said even if they are acting in the best interest of the patients, they may have to opt for certain measures and that may result in death, but it's always after consent of the patients. And the Supreme Court has also referred, in fact, if at all, the Supreme Court has also mentioned that there has been medical negligence that has been observed, the police or others have to refer this through an expert panel. Amid strong resistance from the medical fraternity, Home Minister Amit Shah in the Parliament had claimed if there is death during the treatment, it is treated as murder. Therefore, I will bring an official amendment to free the doctors from criminal negligence. This is what he had spoken in the Parliament. Indian Medical Association continues to protest against criminalization of medical negligence. I'm being joined by Ashwini Dubey, who's an advocate for Supreme Court, Dr. Rajeev Jayadevan, who's a past president of IMA, and Dr. Sanjeev Bagai, who's a chairperson for Nephron, as well as Aditya Pratap. Thank you very much, all four of you, for joining us.
Thank you.
Dr. Rajeev Jayadevan, first. Help us understand what really is your big concern. You know, there are two sides of this. I mean, we were trying to get to a doctor who would speak in favor of this, who would say, you know, at least who would say that, okay, this has come into effect. We couldn't find any doctor. Maybe you could lead us to a doctor. But nonetheless, strong opposition from the fraternity of doctors against this particular clause of BNS. Why?
If doctors don't take risks, they can't save lives. That is true. All of us, including doctors and all individuals in society, at some point, we will need a doctor when we are critically ill to fearlessly take decisions and prescribe medications or do operations in our time of need. There's no exception. Now, if we create a society of doctors who are constantly fearful of being arrested by the police, that is not a healthy society of doctors. I'll explain why. Let's look at the suicide that occurred in 2022 by the gold medalist, Dr. Archana Sharma, who is a gynecologist. She wrote in her suicide note, postpartum hemorrhage is a severe complication. Please do not harass doctors. Yes, she was harassed. Somebody filed a case for murder because a woman under her care died of hemorrhage or bleeding after delivery. Now, the death rate after delivery in India is 1 in 1,000. Yes, that is true. Do we not have to reduce it even further? And my obstetrician colleagues tell me, gynecologist colleagues tell me, very few youngsters are willing to take up the art of delivering babies. They are opting for infertility and laparoscopy instead. They are shying away from the risky, what is called the doctor who stands by the side of a pregnant woman delivering her baby safely. Now imagine this happening on a countrywide scale. If we don't have doctors who are bold enough to take risks for their patient, what will be the health of our society and of the babies that are born? I'm just giving you one example. I understand that laws are made with good intent, But learned legal luminaries have said that's the implementation of the law on the ground that makes all the difference. So if we have a criminal case file for every death that happens in a hospital, we are going to have a cure for a disease that is worse than the disease itself. That is the contention. Yes, doctors who are grossly negligent must be held accountable so that they do not repeat those acts. But there are other methods of getting that done. But the vast majority, 99.999%, who do not engage in that, you should not put them in fear of their own lives through violence or through criminal proceedings. Thank you.
Okay. Ashwini Kumar, if I can come to you, do you agree with what Dr. Rajeev Jayadevan is saying? Is there intent on one end and the implementation on the other, and the distance between the two is quite far?
There is a thin line. What is to be seen? That an improper, unskilled person not having the efficiency to treat that particular patient is carrying out any medical procedure and person dies. In that eventuality only, Section 106 of BNS applies. Why? Mens rea. And intent is that there are two important components of a law. The duty or obligation of care in finding out whether to undertake an unique case or not. This is one. Supposingly, I'm a law student. If I'm not able to do any complex issue of legal or any important complex issue, then I should say, so sorry, I don't have expertise on this. So question arises here. If there is a proper care, person has skilled, person is not negligent, then in that case, the law itself says, Section 106 itself says that there is no 106. Earlier also, even if you see Section 304A, there was a medical negligence, though it was a punishable for 2 years, and also the civil liability, tortious liability, that was there. Here, just has been increased for 5 years. That too in that case where the reckless or thoughtlessness behavior, which does not constitute culpable homicide and person died. Why I will say, one person visited to Vedanta, Lucknow, you must have read in the social media, then immediately doctors started surgery have to be done. And when he visited to the registered medical clinic, gas hua hai. So 3 lakhs rupees which he was about to deposit in a big multinational hospital or corporate hospital, he was just cured for 1,500 rupees. So don't you call it an attempt by a person who is there just to make money? Yani, patients are not the object. Why? When an accountant makes a mistake, there will be a loss of money. But if a doctor makes a mistake, there is a threat of losing a life. And this law makes a line where we have to be cautious enough while treating a patient. Over to you. This is the law says.
Okay, Dr. Sanjeev Bagai. Now let me ask you this question. You were there on the panel when we were discussing the deadly Delhi fire where infants were killed. I'm using the word infants were killed, they had died. And eventually what we got to know was the doctors who were appointed there were not qualified enough. They were not doing the job that they were meant to do. Negligence would be just one word, but nonetheless, it was negligence. It was far beyond negligence as well. Now, how do you differentiate? The law is very clear. It's medical negligence. You have Dr. Rajeev Jayadevan and you have yourself who believe that this is not about medical negligence. This is going far beyond and creating an atmosphere of fear, paralyzing the doctors. But there are two extremes to this as well. You do have acts of negligence by doctors that have serious ramifications, including deaths. And we saw it. We have seen it play out time and again in India. Latest being the Delhi fire cases, that was, at least in the intensity of the reports that have been reported. And now, why equate the two? Is it really that paralyzing? Aren't these for two different cases?
Okay, 4 very important points, and I think it's important to differentiate the terminologies and the understanding and perception. It's important to differentiate and understand what medical negligence is versus medical malpractice. Medical negligence is a deliberate, established act of omission or commission. It's a deviation from a standard protocol or procedure which a common doctor would do for that disease or illness, causing injury or death. Malpractice consists of various types, including injury, malpractice of intent, malpractice of financial needs, referrals, cuts, commissions, employing unqualified people in the hospital, and so on. Here, the difference here is that the doctors, just allow me exactly 60 seconds, doctors are not routine service
No, please
providers.
go ahead. Take your time.
Doctors are people who spend the better part of their youth and their early adult life just in academics and training. We spend upwards of 12 years to become a specialist and another 10 years to further advance our skills. And let me explain, in these 20, 25 years after leaving school, life is not easy. There are boards, there are state boards, there are medical review forums, and there are various other platforms where cases of suspected medical negligence or alleged medical negligence are scrutinized. A patient cannot decide whether it's medical negligence. Neither can a police or a local police station. We cannot precipitate an environment of fear, anxiety, or uncertainty in a doctor's mind. Doctors have to take split-second decisions to save human lives. I'm in pediatrics and pediatric nephrology for the last 30, 35 years, and we know what we go through every day, every minute. The fallout of this is, if there is a fear, if there is a cause of fear in doctors' minds, they will stop taking critical cases. They will take cold cases. The cost in terms of healthcare to the patient will increase because the doctors will practice what we call as defensive medicine. There will be more number of tests, more number of investigations, and the ultimate burden is going to be on a patient.
Okay.
If a doctor does a deliberate act, surgery on a wrong limb, surgery of from an untrained person, 100% that person has to be held accountable, liable. Whatever is under law, 100% done. But there has to be a differentiation, a genuine error of judgment, a genuine differentiation in line of treatment is not negligence or malpractice. Remember, doctors work only in the best and only in the best interest of patients. A cause of death is a natural cause in many cases. Doctors cannot save every human life. Our endeavor, our faith, our trust is with the patients. Laws like this will create further distrust between doctor-patient relations.
You made your point, sir. Okay, Aditya Pratap, before I come to you, let me just allow me a few minutes. Give me 2 minutes, Aditya Pratap. Let me just go back to Ashwini Kumar. What would you say, Mr. Ashwini Kumar, to what Dr. Sanjeev Bagai has just said, that the patients and the police is not capable to decide whether it is a medical negligent act or not?
But the subsequent medical treatment, that is what the law says. When there was no BNS, no 106 subclause 1, then there was a 304A. If you approach to the National Consumer Commission or State Consumer Commission, subject to what kind of amount you are seeking, there has to be a subsequent opinion of a doctor. And if not, then there has to be the medical jurisprudence of a reputed institution like All India Institute of Medical Science, whether the medicine, whether the treatment which has been provided, those are in consonance, or those are for the treatment of the patient's the disease, what he is having. That is why there is a settled law. The Supreme Court has stated that each and every health practitioner has a responsibility to act with an affordable amount of care and skill. As I said, if I don't have any knowledge of a mining law and I take up a matter of mining law, then your matter will definitely, how will I justify taking that matter? So that is why the obligation to seek is the first component of the medical jurisprudence. Then prognosis is the second component. Then patient's delicacy and secrecy in the patient must not be neglected. This is one. Giving medical aid does not amount that you have a right, you have a knowledge for treating the cases which have to be dealt by the statesman like Mr. Dr. Bagai. Not each and every person. मुझे नहीं पता है अगर कि मुझे क्या इलाज करना है, and I start putting the syringe and cutting things, that is to be taken into account. और इसीलिए medical negligence की जो first foremost जो accountability है, that has to be by virtue of a medical research. And that research is not from the Google, that research from the institutions, that research based on the doctors who have expertise over that. Over to you.
Okay, Dr. Bagai, I know your hand is up. I'll allow you, but Aditya Pratap has been waiting on this panel. Let me just go to him. Aditya Pratap, to what Mr. Ashwini Dubey has spoken, let me just ask you this question. There is a new act in place, there's a new law in place, but there's also precedents of Supreme Court's judgments. And out of Supreme Court's judgments, it has been established that if there is medical negligence suspected or preliminary found, there has to be an expert panel that will then look into it. So while you have the BNS or the new criminal law, which states that there is criminalization of medical negligence, to establish that or to reach that conclusion based on a suspicion or a complaint that may emerge, wouldn't then the precedents of Supreme Court's judgments about medical panels also be reflective in it about how it is seen on ground, how it is implemented on ground? Isn't that how it will go forward?
Well, the Supreme Court of India in 2013 passed a constitution bench judgment in the case of Lalita Kumari versus State of UP. In Lalita Kumari versus State of UP, the Supreme Court held that when the facts prima facie disclose a cognizable offence, an FIR can be registered. But in certain cases, a preliminary inquiry is necessary. And one such instance was medical negligence. Honorable Supreme Court held that when medical negligence is alleged, especially when it's a case of latent medical negligence, like medical negligence is of two types, patent and latent. Patent is like leaving a scissor inside the person, feeding a person a poison instead of a medicine. That does not need any application of mind. But when it's a case of latent medical negligence, when a person has to go into the merits or demerits of a technical decision taken by a doctor, then Honorable Supreme Court held that in such cases, there has to be a preliminary inquiry. Now, the biggest concern with Section 106 of the Bhartiya Nyaya Sanhita is that it probably does away with the requirement of a preliminary inquiry. Now, let's come to say, I would like to say for a fact that there are three kinds of professionals a person deals with in his lifetime: lawyers, doctors, and bankers. Bankers, if they go wrong, they will face maybe IPC 409, which they rarely do. If a lawyer goes wrong, he only faces bar counsel disciplinary proceedings. But if a doctor goes wrong, he will face consumer case, police FIR, as well as a misconduct or disciplinary inquiry with the medical commission. So which is why, and doctors perform the toughest task, which is why it is all the more necessary that the law should have had an inbuilt safeguards to protect medical practitioners. Do you know what happens when a medical practitioner undergoes disciplinary proceedings? His peace of mind gets destroyed. He's unable to treat other patients. And let me just tell you, when in the amended Prevention of Corruption Act, you have put in 2233 levels of protection for corrupt public servants, why did you not put in protection for doctors? So yes, the Bhartiya Nyaya Sanhita in its current form is vulnerable to, excesses, but I do hope that the concrete precedents laid down by Honorable Supreme Court of India.
I don't even think we need to get down doctors to compare them to the level of politicians for that matter. But Ashwini Kumar, the panelists here really saying that they need an environment for protection. They need an environment where they can perform their basic duty without fear. But so are we essentially then worried and looking, the way there's no doctor, even one doctor who came out in support of this law. There have been protest after protest for the last several months. The Home Minister did make a statement in the Parliament about this as well. Have we overlooked what may have been the intent and what might be the result of this law?
What has come now? Nothing has come now. Why? The act of misconduct, the abuse of professional position was already defined way back. The Supreme Court and various other forums have already decided. Not taking the consent of the patient. Why? The mens rea is important, intent is important. As I cited the example of a Lucknow patient, you have also gone through that. If not, then I will share. violation of regulation. Laws are already in place. The medical professionals must follow the rules and regulations regarding the duties and responsibilities laid down in the Indian Medical Council. They've just called the Professional Conduct Etiquettes and Ethics Regulations. Right to know the information. The doctors must inform the patient that, look, this critical disease or critical illness you have, and these are the procedures which are to be followed. 1. 2. Right to see and check records and report related to their ailment. 3. Right to receive medical care during an emergency. These are the components. And if there is violation of regulation and laws, if there is a negligent act, then only section 106 will come. As I said, it is very much written in the 106. What is it? Whoever causes death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either description for a term which may extend to fine. 5 years of fine. Means by doing any rash negligent act. How do you justify? It's not policeman is going to justify. The act of the doctor itself, the procedures given on the summary, the medical summary, and they are not in consonance with the medical jurisprudence, then only this section will apply. Why don't you want to check and balance? That is the question here.
Okay. Let me. I'm less on time. Let me just quickly go across to Dr. Sanjeev Bagai. Please respond to Ashwini Kumar. He's saying it's been specified. The specifics have been laid down. These things have been already defined. Dr. Sanjeev Bagai and Dr. Rajeev after that. Very quickly, Dr. Sanjeev Bagai, a minute and a half to you.
Yeah, Ashwini, the unfortunate aspect of life is that beyond the legal gamut of giving statements or a particular law which is there in a book or its implementation or rather wrong implementation, medical science is a lot more complicated. My only statement would be that let the doctors enjoy the romance of practicing free medicine. Let them save lives. I'll just give you a very small classical example. Almost a decade and a half back, I got a call, and very quickly let me narrate this, that there was a very rarest of rare cases of conjoined twins called as Geeta and Sita from Bihar. Would you like to take these children on? We took these children on. These were critical kids who were joined with almost every pelvic and chest and abdominal and hip organs. It was a complicated surgery which we undertook with all due precautions. These kids are alive. These kids are well and now teenagers in Bihar. You save human lives by taking calculated risks in the interest of patients. If the law is a detriment towards practicing freely with a free mind, but with conscience, then the critical cases will not be taken up. There is a medical forum, say vis-a-vis in Delhi, known as Delhi Medical Council. It's an extremely strong and robust council. Doctors have been hauled up, but let the doctors practice medicine for the beauty of medicine.
Point taken, sir. Point taken. I'm totally out of time. Very quickly to you, Dr. Rajeev Jayadevan. How is the Doctors Association, the IMA, and so many other associations going to take this forward? At the end of the day, this is a rule already. This is a law.
Yes, there are widespread discussions going on, and all doctors are in agreement that this is not the way to go forward. Let me conclude by reading a judgment from our Honorable Supreme Court. It is our bounden duty and obligation of the civil society to ensure that the medical professionals are not unnecessarily harassed or humiliated so that they can perform their professional duties without fear and apprehension. Those are the words of the Honorable Supreme Court of India. Over to you.
Right. Thank you very much, all of you, for joining us. This is a hugely important issue. While the law is very clear, this is against medical negligence. There are huge concerns that doctors also seem to be raising. The impact directly on the society and people. Thank you very much for joining us. Up next at 7 o'clock, South Speaks News at 7 with my colleague Ashish Parekh.